All right, so we're being recorded. Welcome everybody once again. Courtney Orr, Vice Chair, sitting in for Deb today. Welcome to the December quarterly meeting, and Tina will call the roll now.
Hey, good morning, everyone again. Melanie, Bean, Jean, Bardwell.
Here, I'm here.
Okay, thank you. Michelle.
Here.
Okay. Chelsea.
Present.
Thank you. Judge Blackshear, Dalton. Dericia. Sarah Davis.
Here.
Thank you. Deb Faulkner.
I'm here.
Thank you. Representative Farmer. Aaron Ferguson.
Yes, ma'am. Good morning.
Thank you. Good morning. Lena. Evelyn Guzman. Sue Jones. Regina. Judge McMillan.
He's on.
Yeah, he's here.
I think he stepped out of his office.
Okay, no worries. Thank you. Stacy.
Present.
Courtney.
Here.
Sheriff Russell. Judge Snyder.
Here.
Thank you. Bobby. Senator Wally. Kathy.
Here.
Thank you. And Dale. Madam Chair, those are the attendees thus far. We do have persons in the waiting room, and I will adjust the attendance accordingly. Thank you.
Thank you, Tina. The minutes from last meeting were sent out earlier this week. So if you haven't reviewed them, please take a couple minutes to do that now.
This is Chelsea Curtis. I motion to approve the minutes.
Thank you,
I'll
Chelsea.
second.
That was Judge Snyder was the second. And then when making motions or seconding, please identify yourself so we have them for the minutes. Now, Kathy, we'll explain this later, but we're going to do this by roll call vote this time. So Tina, if you can go through the roll call vote, and we will vote to approve the minutes.
Yes, ma'am, sure will. Thank you. And these are the ones who are in attendance. Jean.
Yes.
Michelle.
Yes.
Thank you. Chelsea.
Yes.
Sarah.
Yes.
Deb.
Yes.
Aaron.
Yes.
Judge McMillan. Judge McMillan.
I'm back. I had IT interrupted me to find out why I wasn't being able to participate, and now I'm back. I'm sorry.
Okay. And so Courtney, would you like to let him know what we're doing right now?
Yes, Judge McMillan, we're doing a roll call vote to approve the minutes. So if you've had a
Okay.
chance to review them, yes or no.
Yes, I could hear that, and yes, I'm here, and I approve.
Thank you. Stacy.
Yes.
Thank you. Courtney.
Yes.
Judge Snyder.
Yes.
Kathy.
Yes.
Okay, very good. And that concludes those who were here at the present before the meeting started, Courtney. However, it looks like Regina is on now.
Yes.
Okay.
Okay. Well, with that, the minutes from last meeting are approved. And we will move on to the committee reports, starting with certification and monitoring, and Stacy. Stacy, you're still muted.
I've got a long list today, so I'm going to try to do what judges call the rocket docket and go through these pretty quickly as I can, because I know we've got a lot to discuss. The first program that we have is going to be Avalon Center. The Avalon Center in Crossroads serves Bledsoe, Cumberland, Fentress, and Morgan, Van Buren, Ray, and Roane counties. They submitted all their paperwork, including their $200 payment for recertification. The committees reviewed the paperwork and discussed the program. Two virtual monitoring visits were attempted on November 16th and the 30th by myself and Ms. Fox. However, they had no participants. The program is requesting a 3-month extension to have the class monitored with participants. They have been a long-standing program across the state, a reputable program. They just currently do not have any participants for them to be monitored to finish up the approval for them to be recertified. So we are asking for a 3-month extension for them till after the first of the year to see if they can get their numbers up and get some numbers in, some referrals, so that they can be monitored. So we're just requesting a motion to approve that.
Question, why, is there a reason they don't have any participants?
Well, Judge, that is something that we actually discussed in our meeting today, and we've been discussing the last, couple times this week. We have 4 programs today that we're going to ask for 3 other programs in addition to them for 3-month extensions as well. These programs are in West Tennessee, Middle Tennessee, and East. Even my own program that serves 6 locations, even our numbers are down in all of our locations. The referrals are not coming in. And so this is the first time we've had this many programs that are long-standing reputable programs that's been around that are not getting referrals made. So we did kind of come up today with a preliminary plan to help the programs and to start working towards that as a committee. But we've got 4 programs today that we cannot monitor them because they don't have participants.
Well, I can say for purposes of Henry County, what I'm seeing are our DAs having trouble getting people to court, getting witnesses, victims, and then having them request something other than, a conviction to domestic assault and wanting to work resources and having so that there's not an order for the standard BIP, maybe the 12-week instead of the 28-week. So I have seen a big difference even after, we had the big, during Domestic Violence Awareness Month, and we had the big program. I thought that might, make victims feel like they were empowered to come to court, but that hasn't happened yet. We may see that later.
We did discuss, again, that was a huge election that Tennessee came through this last go around. It was one of the largest that the state has ever had. So we have a lot of newcomers that come in as far as public defenders, judges, district attorneys, clerks. And so, again, we're working on a plan to try to do some outreach and to address that statewide. But it is programs all across the state, programs that have long established histories. It's just, they're down everywhere. We've discussed that, this is even a trend that we're even seeing on a national level. Some of the other programs nationally are discussing this as well. So we want to definitely take a proactive offense to this and reach out as much as we can to see what we can do to change things.
Thank you.
So we need a motion for Avalon to give them that 3-month extension. Chair, I know that since we're doing this individually now, we have 4 programs that we're going to ask for a 3-month extension. Could we loop these all into one motion, or do we need to do them individually for roll call?
I
Is
believe
it all
they
for
need-
the same reason? Is
Yes,
it all because of lack of attendance?
yes.
I think they need to have an individual approval. So I think as long as we do like one roll call vote where it's clear that we're voting to or extend all of them at once, we can do that. So yes, we can do one roll call vote as long as there's a motion and a second for each one.
All right. Let me go ahead then and address the other 3 programs. And then I'll ask for a motion at that time.
Well, so we can make sure that we have things clear in the minutes. Can we do a motion and a second for each one as you report them?
Yes.
Thank
So the first, we'd like to request a motion for Avalon to get a 3-month extension.
I'll make
I'll
the
make the
motion.
motion. I'll second the motion. This is Sarah. That was.
Grab
Judge
that, Dylan.
McMillan. Oh,
Okay, so we have a motion and a second to grant a 3-month extension to Avalon Center. And we will hold a roll call vote on that motion until the other 3 have been reported by Stacy.
The next program is BIP, it's Successful Survivor. It's a Nashville program serving Davidson County. They do have some documents that they need to submit. However, all the participant files were sent. The virtual monitoring visit was attempted on November 17th by Ms. Fox. No participants were to show. The program is requesting a 3-month extension to have the class monitored along with the additional paperwork. And we're requesting a motion for them to get that 3-month extension.
Is there any questions or discussions for this one?
I have a question. So I can understand how in some of the more rural counties, we would have this not having any attendance issue, but in Davidson County? Doesn't that seem a little unusual?
Sheriff's Department.
I'm looking really quick, Sarah, to see where that other program is.
I'm just curious, like if we're looking at other programs in such a large metropolitan area, or is it across the board, everybody's having low attendance? 'Cause, I mean, I would think they would have higher numbers than any other jurisdiction other than Shelby County or, Knox or Hamilton.
Our other 2 programs that I'm going to request next are both Shelby County programs that don't have participants, and they're both from Shelby County.
Okay.
Again, it's something that's baffled us as well. These are long-standing programs, reputable programs that are well-connected directors that are, reaching out. Have always been able to reach out directly to judges and district attorneys. They've been well-connected. They're part of CCRs. The referrals are just down.
Do we know if when someone's convicted of domestic assault, they are being referred and ordered to a BIP class or a program, or if it's just people there's not a conviction to domestic and it's a conviction to a lesser included, or, a set off, a judicial diversion or something of that nature. I don't know, some different adjudication or no adjudication at all. Is there a way to track that?
I'm unaware. I don't know if some of the programs have spoken more in detail with Ms. Fox during the monitoring visits.
Do you know that? Do you know if there's a breakdown in when there's a conviction to domestic, they're being ordered into a BIP? If it's available, they should be available in every jurisdiction actually, but I know they're not.
I'm sure Davidson and Shelby keep statistics on that.
It is something that we can look into and see if that might be some of the issues that we need to address.
I mean, if we have new judges and they're not familiar that they are required to do so statutory, by statute, that's something that they may not know.
And that's what we discussed today in our meeting, is even with, like I said, the election, a lot of times you've got new DAs, you've got new ADAs. They don't know the legislation. They're new. They're still trying to kind of warm up to their position. And a lot of times it's just something as simple as failing to check the box or to write it down. And it just kind of needs, that gentle reminder for a probation lady to show up randomly and say, hey, can I meet your new DA?
Yeah. Very often, and I mean, I have the same assistant public defender for a long time, and I still have to say, oh, you forgot to check the BIP box, or the class, and he'll go, oh yeah, I forgot about that. Well, yeah. And so I'll say, does that make a difference to the defendant? Does that make a difference? Do you still want to enter a guilty plea? It has to be explained, but
I cannot imagine forgetting to put that on.
I agree with you, but I'm being facetious.
I mean, I can understand why the public defenders might not remember, but
yeah,
the
he's
DAs
trying to sell that to his client. But I always ask, do you still want to plead guilty? Does that make a difference? No, I'll go ahead and plead. And because it's required. I mean, that's not a, it's not an option. So we have it available. Stacy's, they provide that.
That's some excellent input. Thank you, Judge.
Mhm.
Thank you, Sarah. Sarah, you ever want to work in West Tennessee? It's flat here, but we'd love to have you. Come on over.
Oh, if you need me to come, I could here and there, but I'm kind of busy over here.
Okay,
Stacy, I have a question. Did y'all talk about ways the council could help provide some judicial education, or maybe a letter to all the new judges and DAs and so on, just letting them know about the VETRS programs and the rules and that kind of stuff?
Yes, we have. Judge McMillan has offered his services to get with, for us to get with John Crawford. He's the one who lines up the agenda for the judicial conferences. Ms. Sue Jones, of course, she's on the council with the District Attorney's Conference. She's not here today, but we also have the plan to reach out to her to get her to draft the letter on behalf of the committee and the council to reach out to all of our district attorneys. So we came up with a preemptive game plan to see what we could get done.
Hey, Stacy, it's Michelle at AOC. We definitely, I know, Judge Snyder and Judge McMillan have been on panels, lately on domestic violence topics. But if there is a letter or a document just as informational that we can blast out to the judicial conferences, that would not take something that, we would put on a conference agenda, but that we could send out now just as notice. So if you have something or a letter, feel free to send it to me. I'll be sure that gets blasted out to the conferences.
Excellent. Thank you so much, Michelle.
Mm-hmm.
okay.
I love when great minds come together.
Yeah, I think this was a very useful discussion, but kind of turning it back to certification and monitoring. Do we have a motion or a second for the BIP at Successful Survivor at Nashville?
I'll move it, Jean.
Sarah, I'll do second.
Okay, so we have a motion from Jean and a second from Sarah, and we will hold the roll call vote on that for a group extension.
Mid-South Diversion in Memphis is serving Shelby County. They've not submitted their paperwork. The program director is currently hospitalized. The program is requesting a 3-month extension to have the class monitored along with required paperwork. So if we are requesting a motion to give them extension based on the fact that their director is in the hospital.
I'll make the motion, Greg McMillan.
Vicky Snyder, second.
Okay, we have an motion and a second for a 3 months extension for Mid-South Diversion. We will hold that vote until the group.
The last program is Hope Center at Grace in Memphis. They serve Shelby County. They currently do not have any participants and haven't since the pandemic. The program is requesting an additional 3-month extension in order to get participants into the class, and we're requesting a motion for that approval as well.
Is this their first recertification since the pandemic?
I believe so.
So, Madam, or if I may, they requested a 3-month extension last quarter and it was granted. And so what they're doing is requesting an additional one for this quarter. Thank you.
What was the name of this one again? I'm sorry.
Hope Center at Grace.
So I have a stupid question. What are they doing if they're not doing counseling?
Hope Center and Grace also does addiction therapy, I believe.
Okay, so that's
other
just
type.
the BIP's like on the side.
Yes.
Okay. Any other questions about Hope Center at Grace? They are requesting a 3-month extension for recertification. Is there a motion or a second?
Sarah Davis, I'll make a motion.
This is Jean, I'll second.
Okay, with that, is that all 4 of the ones requesting
Yes.
extension, Stacy?
Yes.
Okay, so we have 4 groups requesting a 3-month extension with all have motions and seconds. Avalon Center, BIP Successful Survivor in Nashville. Mid-South Diversion, and Hope Center at Grace in Memphis. This will be a vote to approve all 4 3-month extensions. So Tina, if you will call the roll call vote.
Yes, ma'am. Thank you. Jean,
Yes.
Michelle,
Yes.
Chelsea.
Abstain.
Okay, thank you. Judge Dalton is here. Thank you, Judge, for joining us. Judge Dalton.
Yes.
Okay. Sarah,
Yes.
Deb,
Yes.
Aaron,
Yes.
Regina.
Yes.
Thank you. Greg McMillan,
Yes.
Stacy,
Yes.
Courtney,
Yes.
Judge Snyder,
Yes.
Kathy.
Yes.
Okay, all right, Madam Chair, that concludes the roll call vote.
Thank you. Stacy, next round.
All right, I have 4 programs that we are going to request motions for recertification on. Do you want to do them the same, or do you want to do the motion and vote on each program individually?
Kathy, do you have any idea of whether this needs to be done individually or not?
Did you say that to me?
Yes.
I thought you said Kathy. I don't know. I know in the past, we've always done them individually, but with the roll call votes, I don't know if that changes anything, Courtney. So I would defer
I
to,
think just to be safe, since this will be a full recertification, let's do a roll call vote for each one.
Absolutely. The first program is correctional management. It's in Nashville, serving Davidson County. They've submitted all necessary paperwork, including their payment for full recertification. The committee has reviewed their paperwork and discussed the program. The program was virtually monitored on November 15th by Ms. Fox. After discussion, the committee has agreed to recommend correctional management for recertification, and we just need a motion for recertification.
Any questions or discussion?
I have a question. How do they get people in their program?
Good question.
Correctional management has been around for a long time, and they have always had participants. And I know that one of the things that they do is they go to the general session judges regularly. They also meet with the probation department as well. So I am simply deducing that's why they have some participants.
Yeah, and it might be location too, like where in town they are.
Okay. I just know, Avalon's been around a really long time too, and okay, I mean, I don't have a problem with it. I'll make the motion.
Okay, we have a
I'll
motion. And
Fred
Judge
McMillan will second.
Judge McMillan seconds. Okay, we'll do a roll call vote for recertification of correctional management Nashville.
All right, thank you. Jean,
Yes.
Michelle,
Yes.
Chelsea,
Abstain.
Judge Dalton,
Yes.
Sarah,
Yes.
Deb,
Yes.
Aaron,
Yes.
Regina,
Yes.
Judge McMillan,
Yes.
Stacy,
Yes.
Courtney,
Yes.
Judge Snyder,
Yes.
and Kathy.
yes.
Okay, all right, Madam Chair, that concludes the roll call for correctional management.
Thank you, Stacy. The next one.
Our second program is Crossroads Counseling in Nashville, servicing Davidson County. They had recommended it was recommended at our last meeting that they get a 3-month conditional recertification, that the class size was going to be limited to no more than 10 participants per class, and that the council would monitor the program at least 2 times before the next council meeting. 2 virtual monitoring visits were held October 11th and November 18th by Judge McMillan and Ms. Fox. After discussing their program, the committee agreed to recommend Crossroads Counseling for unconditional recertification, meaning they could go back and accept full amount of referrals. We have the probation department and the judges there waiting for our direction, and we have seen the program comply with our recommendations, and we have monitored them as we said we would. And at this time, the committee is recommending that they be recertified with no conditions.
Any discussion? Okay, hearing none, is there a motion or a second for full recertification unconditional for Crossroads Counseling?
I'll make a motion. This is Sarah.
I'll second. Fred McMillan.
Okay, we have a motion and a second for a full unconditional recertification of Crossroads Counseling. Tina, if you'll call a roll call vote.
Yes, ma'am. Thank you. Jean,
Yes.
Michelle,
Yes.
Chelsea,
Abstain.
Judge Dalton,
Yes.
Sarah,
Yes.
Deb,
Yes.
Aaron,
Yes.
Regina. Regina,
Sorry, yes.
okay, no worries. Thank you. Judge McMillan,
Yes.
Stacy,
Yes.
Courtney,
Yes,
Judge Snyder,
Yes.
and Kathy.
Yes.
Okay, Madam Chair, that concludes the recertification vote for Crossroads Counseling.
okay, thank you, Tina. Stacy, next one.
All right, the next one is Shelby County Pretrial Services in Memphis. They are serving Shelby County and has submitted all documents, including their payment for full recertification. The committee has reviewed their paperwork and discussed. The program was virtually monitored on October 27th by Ms. Fox. After discussion, the committee has agreed to recommend Shelby County pretrial for recertification, and we need a motion as such.
Any discussion? Okay, hearing none, do we have a motion and a second for recertification of Shelby County pretrial services?
I'll make the motions, Jean.
This is Vicky. I'll second.
Okay, we have a motion and a second and a very jazzy ringtone from Jean. If we can do a roll call vote for recertification of Shelby County pretrial services, Tina.
Yes, ma'am. Thank you. Jean,
Yes.
Michelle,
Yes.
okay, Chelsea,
Abstain.
Judge Dalton,
Yes.
Sarah,
Yes.
Deb,
Yes.
Aaron,
Yes.
Regina,
Yes.
Judge McMillan,
Yes.
Stacy,
Yes.
Courtney,
Yes,
Judge Snyder,
Yes.
and Kathy.
Yes.
Okay, Madam Chair, that concludes the roll call vote for recertification for Shelby County pretrial services.
excellent. Thank you, Tina. And then Stacy, I think, is this the last one?
One more. The Transformation Center in Chattanooga, serving Hamilton County, has submitted all necessary documents, including the $200 payment for full recertification. The committee has reviewed the paperwork and discussed. The program was virtually monitored on October 27th by Ms. Tina Fox. After discussion, the committee has agreed to recommend Transformation Center for recertification, and we need a motion as such.
Is there any discussion? Okay, hearing none. Does anyone have a motion or a second?
This is Sarah. I'll make a motion.
I'll second. It's Jean.
Okay, we have a motion and second for full recertification of Transformation Center in Chattanooga. And Ms. Fox, if we can do a roll call vote, please.
Yes, ma'am. Thank you. Jean,
Yes.
Michelle,
Yes.
Chelsea,
Abstain.
Judge Dalton,
Yes.
Sarah,
Yes.
Deb,
Yes.
Aaron,
Yes.
Regina,
Yes.
Judge McMillan,
Yes.
Stacy,
Yes.
Courtney,
Yes,
Judge Snyder,
Yes.
and Kathy.
Yes.
Okay, Madam Chair, that concludes the roll call vote for recertification for Transformation Center out of Chattanooga. Thank you.
thank you, Tina. All right, Stacy, anything else?
Had two small things. I just wanted to give an update on the BIPS quantitative methodology pilot program. The BIP participants data was submitted to the Office of Criminal Justice Programs on October 4th. The 4 pilot programs are Avalon Center, Blount County Probation, Coffee County Drug Foundation, and Solutions Education. The Tennessee Coalition's Assistant Director of Programs is responsible for collecting that data from each pilot program and reporting the data to the OCJP. That is the update on that. And I just wanted to let everyone know that our Batter Intervention Conference for 2023 is scheduled for June 22nd and 23rd. June 22nd and 23rd will be our Batter Intervention Program conference that we'll have. That'll be Thursday afternoon and Friday morning for a total of 8 hours.
Okay, excellent. Thank you, Stacy, and thank you. I know this was a big report, so thank you for all the work your committee has done this quarter to get everything monitored.
Miss Tina Fox.
Yeah,
Again,
yes.
I try to do this at each council meeting, but I want to do it again. It just seems like the more I brag on her, the more work she gets. It just gets deeper and deeper for her. She really carries a load. But I'm telling you, if I could steal her away, I'd try to do it. Nobody wants to come to West Tennessee except me and Judge Snyder, but we're here, so come join us.
I will say that with Blue Oval coming to West Tennessee, that's the Ford, that's the manufacturing plant, which will be the largest in the world automobile manufacturing plant. West Tennessee is getting ready to change significantly. So I don't know if that's good or bad. It will be good for purposes of employment. It's probably going to be bad for purposes of driving on the interstate. I'd say probably stay away from the exit by Stanton, Tennessee. I understand that's a really bad as far as exiting the interstate right now. But I'm happy about it. That'll be like 6,000 jobs. Which we need.
It is phenomenal sight to see just right now during the building
Huge.
experience. So
Huge. Yeah. I tell all my kids through delinquent court, and kids in foster care, please go to TCAT. If you don't want to go to college, go to TCAT. Welding, lots of jobs available to you, and this is a great opportunity to get ahead of the game in ways that will give you a great career.
Okay, well, I see we have a hand raised. I'm not sure who the iPhone 4 is.
My name's Mary Jones with Crossroads Counseling.
Okay, did you have a question?
I did. I just wanted to verify or confirm, at the beginning of the meeting, we talked about a lot of the centers that don't have any clients and some of the centers who have a decline in clients. So you talked about what was going to be done moving forward, but I wanted to confirm what that was, because it seems like if that's not addressed now, then a lot of these programs are going to go away. So I'm wondering what this committee is planning on doing to prevent that from happening. And it's my understanding that there are no less offenders out there than there were before. There's probably more, but if they're not coming to these agencies that are available, then where are they going? So is there some way we can address that? And if so, what is it? I just want to make sure that something's in place to address that moving forward. And if I missed it, I apologize.
Stacy?
So are you from Crossroads, Mary?
Yes, ma'am.
Okay, and so you're not one of the organizations that's having trouble getting clients, right?
No, ma'am, we are. We have clients, but compared to what we have had in the past, it is, a significant drop.
Do you have any thoughts about why it's happening? Because that's one of the things we were talking about, is trying to figure out what the problem was to determine how to address it. Since you're down at the front lines, I'm curious what your thoughts are.
Yes, ma'am. It's my understanding that a lot of the clients are being referred to in Davidson County, the Sheriff's Department. I believe that's what it's called. And Tina or Karen can correct me. But the Sheriff's Department will take clients who are considered, I guess, indigent and unable to pay their fees. But we have actively gone into the court system to talk with DAs, to talk with the judges, to make sure that they know we're available. We have paperwork in the courtrooms to know, let them know we're there and available. But if the judges and if the DAs and who else, the parole officers don't refer them or let them know that we're there, then yeah, like I said, we're gonna eventually go away because the clients are not coming.
Can
So I don't know if it's a judge referral or a parole referral or a DA referral. I don't know that part of it, but I know that compared to where we were and where we are, and the fact that they're telling us that there's no less clients than there were before, then something's going on and it's happening statewide. So I don't know.
I see Chelsea and Miss Singh have their hands raised.
Yeah, I was gonna ask, what is the fee that your program charges for each class?
We reduced our fee. It was like $30 a class. Now it's like 25 per class. And most clients get 28 weeks. So you're talking about $700
Right.
on average.
Do you know what the sheriffs are charging for their classes for indigent people?
Well, if they're certified indigent, I don't think they have to pay anything. And if the sheriff's department is going to, be in that business and do that more and more, then that's what I'm saying. Then eventually we won't, have any clients to service if they're all going to go to the sheriff's department. And if that's what the sheriff's, and I know that they have like an office of family safety, they're expanding their offerings and things like that. And we, that we could work together with them, but I don't know if they're, what their goal is to, take that entire business from the private agencies. I don't know.
Ms. Jones, have you reached out to the sheriff's department that does their BIP program and tried to partner in any way to collaborate to grow your CCR between the two of you so that you could work together in a unified response in the community and in the court systems to build both programs? Have you reached out to them in any form or fashion or any other programs there in Davidson County?
We have not reached out directly to the sheriff's department, but we have talked with the judges themselves. And we have a relationship with, like I said, some of the parole officers. We have a relationship with some of the court clerks that are there. So that's who we've tried to work with because we have a long-standing relationship with them. But we keep getting kind of caught in the middle as to whether or not it's the judges who are in charge of where these people go, or if it's the parole office who are in charge of where these people go. But we're front and center, letting them know we're there, but it's the referral part that we have no control over. So no, we have not contacted the sheriff's department directly. We have talked with the judges themselves, with their clerks, and with the parole officers.
I certainly don't want to take up all the time because I think this is some of the public comment section as well. I will say this, Ms. Jones, before you came into the meeting, we had actually already discussed what the committee had said that we had already discussed and what we were going to try to work on before our next meeting as a committee, and where we need to, as a council, reach out to those particular individuals, agencies, and organizations and representatives to try to, again, reignite the fire and the information about BIPs, what the legislation statutes state, and what we can do to increase referrals to the programs. We definitely have the same concerns that you have. We certainly don't want to see any BIPs go to the wayside. The whole purpose and why we do this is victim safety, and anything that we can do to keep victims safe, we want to be able to use any resources at hand to be able to do that. And BIPs are very valuable across the state. So we do recognize that the numbers are down statewide, and we're going to do what we can do to try to change that.
Yeah, I see a couple other raised hands. We do need to move on because we have other things we need to get through in this meeting, but if there's any last comments about this.
If I, just my 2 cents very, very quickly, from what I've heard, why people are not referring, in Knox County, it's supposed to be 45 weeks. And from speaking with the probation officers, there's a lot of hesitation because they want the clients to succeed. And they don't feel that $25 a week for 45 weeks is something that can be accomplished. So why put them in a situation where there'll be failure? That's all.
Okay, well, thank you very much for that insight. Okay, Stacy, is that the conclusion of the report for the Certification and Monitoring Committee?
Yes, Madam Chair, thank you.
Okay, and I would say we will hear from you next meeting about how to address some of these attendance issues. Thank you, Stacy. Next, the emerging issues in order protection met this morning via Zoom. And Michelle, do you have a report for us?
Hey, yeah, I'll be quick. We can get back on track really quickly. We discussed a few things. First, I wanted to thank everyone that gave feedback on the automated order protection form email that went out after the September meeting. Our office received that, and Louise Worthland is working on making some of those adjustments so that we can make sure that it encompasses the needs and is actually user-friendly and will work and will be a good option for those that want to complete the forms electronically. So we're working on that. There's not really a time frame as far as, a requirement that they have to be done or a time frame that we've all set out that, okay, we would like it. Obviously, it will be a convenience and a good option to give to, everybody who fills out the forms, from law enforcement to victims to everyone. And we're still working on this because we want to make sure that they are and the best form possible before we release them publicly. So we talked about that. We also talked about back in March of 2020, our March 6th meeting of 2020, we approved making a couple changes to the dispossession of firearms forms, just to make sure that they comply, that they track the statute. They're not huge changes because they all got approved March 6th of 2020. They got off of the radar for the AOC because of everything that happened then. So we're just going to go back, make sure we get those done, get those out, and just technical stuff. And then we also, the big thing that we talked about was we're going to wait to do this in July, but when we were looking at the code, also with the affidavit of firearms dispossession, we have on our website, the AOC, we have a firearms declaration that references Title 36, so the order protection section. Then we also have in, not the order protection listing of forms, but in our trial and general sessions court section of our forms, we have the dispossession of firearms form that references Title 39 and 40 for convictions, domestic assault. And when we were looking at the two codes altogether and questions we've gotten from, like we've talked about, was mentioned earlier in this meeting, new judges, new DAs, new ADAs, just a lot of people that are new to the judicial system, trying to make sure that they understand what forms to use, that perhaps we may want to combine those two forms because essentially they have the same information. The code pretty much, it references the affidavit of firearms dispossession. It does not mention, quote, a firearms declaration form. So we may mainstream that just to make sure everything tracks the code. There's one form, the same things used. We're not getting, two different forms for two different situations. But we're going to work on that right now, and we'll have a draft, and we'll have that to put out for June, for July 1 implementation, because that's typically when we have new forms, especially when new laws go into effect, all of that. So I just wanted to make sure everyone had a heads up. We're looking at that. We'll have more information to come, but that's something that we want to make sure is just streamlined and obviously tracks the code and is most efficient for all parties that use these forms. So that's it. That's what we talked about. So.
Thank you, Michelle. Is there anything that we need to vote on?
There is not.
Okay, great. All right, thank you for that report. Bobby Van, I don't know if Bobby's here.
He is not, Madam Chair.
Okay, do we have a training and education report from him?
Yes, ma'am, it was sent out on
Okay.
Monday of this week, yes.
So, yeah, that was sent out earlier this week to the council. If you guys have any questions, if you have a chance to review that. Otherwise, I think we can move on to Kathy's report about the public information electronic means policy.
All right. Tina, am I able to share my screen, or is that something you would need to do as the host of the meeting? Because I just want to show that we emailed this draft out this morning, but in case y'all hadn't looked at it, I thought maybe we might pull it up on the screen.
I just made you the co-host and I can also pull it up, whatever your preference is.
Oh, if you can pull it up for me, that'd be great. I'd appreciate that. All right, so what this stems from is there was legislation that was passed relative to meeting participation by electronic means. And so we want to make sure that the council is in compliance with that statute. And so Tina and Courtney and myself and some others went through the legislation, and we put together this draft protocol for you guys to look at today. And I'm just going to go through that, and then certainly we want to have any input from council members about what they think, because this is a new thing. So one of the things we need to do is announce meetings held virtually. So I think we're already doing this, but ensuring that we have a protocol that meeting announcements will be posted on the social media pages and website of the coalition at least 30 days prior to the meeting. Post a link for members of the public to join the meeting. And again, the coalition will post that on their website. We now have to do roll call votes. So you'll notice that was something new that we did today. So we will conduct roll call votes for anything which needs decisions. We're also required to record the meetings and retain the recordings of the meetings. So that's why we recorded the meeting today. So those meetings will be retained on the coalition's YouTube channel, which allows access for DVSCC members who may have missed the meeting or members of the public to view and listen. And then the procedure for public comment that we're suggesting is that all public comments should be sent to the DVSCC secretary at least 48 hours prior to each meeting. And those written public comments will then be distributed to the DVSCC members before the meeting, and then we'll keep them as an attachment to the meeting minutes. And when we have requests from the public to be placed on the meeting agenda, this is something that we have always done, to actually be placed on the agenda, then those requests will be approved by the chair prior to the meeting. So this is what we've come up with. And again, we really want you guys to take a look at it, and you can, the statute is on there. So if you want to go and also review the statute and you have any additional thoughts about what we need to do about this policy, we would love to hear from you. And that's the end of my report.
I guess the biggest question I have from our discussions of this is, what procedure are we going to have to address public comments in the meetings? Because public comments without addressing them is not very useful. So I don't know if you have any thoughts about that, or if the council has any thoughts about how to address the public comments that come in.
Again, I would love to hear what folks have to say about that. I know in the rulemaking process that, and again, y'all correct me if I'm wrong, because it's been a long time since I've been through rulemaking, but in that rulemaking process, people would submit comments, and then the body would have to respond to those comments. And so I guess one way would be, would there be a written response to the comments, just thanking people for those comments? And if so, is that something that you would want the secretary of the council to do? Or again, how would you like to proceed with that, or other ideas you guys have?
The silence is deafening. Sarah, you're muted.
You're muted.
I don't think anybody knows what these public comments might be. So it's like, okay, well, is it something that we need to announce in the meeting? Like, okay, next up on the agenda, we have public comments on this issue and we could announce the public comments. I don't know. And then if anybody wants to respond to them, are you saying, Kathy, you think we should do like a unified response? I have no idea. I don't think I think that's why no one's saying anything, because nobody knows what the answer is.
Well, you know, like I was trying to do some research with other groups that might be doing this. And I know Jennifer Eskew on our staff had provided me with some information from a different group that she was on. And, you know, basically, and Jennifer, you jump in here, you know, they had a disclaimer that they put on their website. And I think maybe in the meeting notices, you know, this is not a body that, this is an advisory group, you know, we don't make policy, we don't take positions on bills. We'd like to hear your comments. And then again, Jennifer, I think it was, thank you for your comments, right? Now, if you want to expand upon that.
Yeah, so I served on a state advisory council for the education of students with special needs. And those were the rules. Because we weren't a rulemaking body, we're not a legislative body, we're just advisory council. So all we could do was when someone had a comment they wanted to make, there was a time limit on the amount of time that they could speak, or they provided them in advance. And basically all we could say was, your comments were noted, thank you for addressing them. So people did sometimes arrive with the idea that we could, you know, perhaps solve their issue, but we tried to clarify that that wasn't really the case, because that wasn't really the purpose of that body. So yes, thank you for your comments was basically how we responded to everything.
But what if the public comment is in relation to the performance of a Betters Intervention program? I mean, that is something that we could address.
I mean, I think that maybe that's where the 48 hours comes in, and why they might be attached to the minutes is we can kind of filter them on the front end. If it's something that we can actually designate to a specific committee, it's within the council's purview, then we can do that. And then it can be addressed at the next meeting. And then everything else, we can just say, you know, thank you for your comment. And that's it, because since it's public comments, we have no idea what's coming in. And I think maybe we just kind of screen them to see if this is something that we can or should handle, and give it to the appropriate committee. And otherwise, you know, we can announce them and then just, you know, acknowledge them, because I don't want any public comments not to be acknowledged.
Mm-hmm. Courtney, I think that's a great idea. And I'm wondering if we might need to make that time frame a little longer, because I'm just thinking about if we only have 48 hours to receive those comments, sift through them, decide if they need to be sent to a committee or not. I wonder if we have some, you know, I can't remember if 48 is part of that statute.
Yeah, I mean, it's been, you know, a couple weeks since I read the statute, but I don't think there is a time limit within the statute. So whatever the council or the coalition, Kathy, because since that's kind of involved too, thinks is a feasible time limit. I think it would have to be within the 30 days since we have a 30-day notice, but no, if we want to extend the time limit, I think that should be acceptable.
Mm-hmm.
I'm sorry, I may have missed this, but where do the comments go?
Well, right now for the what we're talking about in the draft policy is that people would send the comments to the DVSCC secretary, which is me, at the time frame. Like right now it says 48, but I'm thinking we may need to broaden that a little bit. And then once I would receive those comments with Tina and I would, because she's the council designate, we would probably forward those to Tina. We would go through them and we would determine, as Courtney suggested, you know, does this need to go to a committee or to the full council, but we would also forward those out to the council members prior to the meeting, just like we do other materials, so they would have an opportunity to see them. And then those comments would be attached. These are the written comments to the minutes of that meeting, because I think that would be a good way to document those comments. Does that answer your question, Jean?
Well, I'm just wondering if they will be posted somewhere, because I have a little bit of a concern about that. It's like, I think we should be able to put a disclaimer on there that vulgar or threatening language, you know, that we have the right to delete anything like that if somebody, you know, makes a threat or talks trash about a program in vulgar terms. I don't know. I just don't want it to become a sounding board for these people who are sitting on their couch, you know, and just have something awful to say.
Jean, would that be something where you could draft some language for that disclaimer?
Did you ask Jean?
Yeah, Jean Broadwell, I was asking if you might draft some language for that disclaimer that you were just talking about. We have the right to not post certain things with vulgar language or whatever. Are you still there, Jean?
Sorry, I was talking along. I just don't want us to put in our minutes somebody's vulgar rant or something like that. I just don't want that really attached. I just want us to have some say so. You know, I think we should read whatever comes in, obviously. But you know what I'm saying?
So Jean, could you draft some language for that disclaimer? Okay.
Sure.
All right. Great. Draft that and send it to us and we'll spread it around and folks can look at it. But again, this is all new. So we are just open to whatever this council feels like is a good process that will ensure that we're in compliance with this statute.
And I will say because there's a question in the chat, we do have some comments that were submitted before today's hearing, or not hearing, meeting, which we'll get to at the end of the agenda. So those will be, if you have submitted within the 48 hours, we'll get to them. But as for the actual policy and adopting this policy, it sounds like we need to do a little bit of redrafting and re-editing. So I don't think we need to have a vote to approve it today because we do not have the final language. But with that discussion, is there any other comments about that issue or any other concerns? Otherwise, we will tweak the language and try to come up with adopt some of the policies discussed today for the next meeting.
Thank you, Courtney.
Okay, Judge Schneider is also signing off. So thank you, Judge Schneider. Okay. So that will be, we'll continue this conversation. This is going to be something that we will be adjusting to and trying to figure out as we go along. Which brings us to the next item on the agenda. The proposed meeting dates for 2023 are March 3rd, June 2nd, September 8th, and December 1st. I feel also incumbent to announce that Deb has announced that she will not be running for chair again at the end of this coalition's fiscal year. So if anybody's interested in being chair or joining the executive committee, please keep that on your radar, because Kathy will be asking for people to volunteer at some time soon. So next, we did have one group ask to present. That's Tennessee Safe Parent Organization, and we will now hear from their representative. Possible.
Sorry, I had to figure out how to turn my mute off quickly enough. Yeah, I sent in, my name is Heather, by the way. I have been in touch with a few of you guys. I recognize names through emails or whatnot, but I wanted to touch base with you guys and see what plans the state of Tennessee has in moving the judicial system forward in more of a trauma-informed approach. We already do that with our public schools. We already do that in our healthcare systems. Many organizations have trauma-informed administrators. We do the handle with care notes for kids going to school. But Congress has put out 2 times, one in 2018 and one in 2022, the need for more training in trauma-informed approaches within the court system, specifically more on the private court system. So chancery circuit sessions. And in that training, in my research in that training, and you guys are the experts in this, so I want you guys to please let me know if I have obtained wrong information. But according to the Board of Judicial Conduct and the CLE Commission, attorneys and judges are not required to receive any training or continuing education training in domestic violence or child abuse. And when I asked about Title 38, the CLE Commission told me that they had no idea who oversees that, who enforces it, or if it's even being done. And so with about 80% of the population having trauma, it's safe to assume that the majority, if not all of those stepping into the justice system are trauma victims of some sort, whether it be an adult or a child. And I feel like this is more of, you could almost consider it to be an ADA type issue. If we had a hearing impaired litigant or some other kind of impairment, we would have to step up and make those accommodations. And so I would like to hear what you guys do with the council. Kathy Walsh told me about this council. I had no idea that it even existed. But I wanted to know what you guys do on your end to enforce Title 38. And if we're moving here in the state of Tennessee to more of a trauma-informed approach, we have the Adverse Childhood Experience Study, we have the Saunders Study through the Institute of Justice, and how we're using that current research within our day-to-day practices.
Does anyone have a comment?
Madam Chair,
Hey,
Chelsea's
well-
hand is raised. I'm sorry, Michelle.
Go ahead, Chelsea, go ahead.
Yes, I just wanted to just speak on behalf of the public defenders, Heather. We have begun a social worker program. So certain public defenders offices, we're eventually hoping that every public defender's office can have at least one, if not two, social workers who are obviously specialized in, working with victims of trauma. Obviously, lawyers aren't generally trained or equipped in that way, but we are starting, and we have, I think, 14 social workers statewide. That may be wrong, but something about like our bigger offices, Knoxville has a really good social worker program. And then we have some spread out throughout the state. So that is something that the public defenders are interested in working towards.
Thank you for that.
Michelle,
I'm definitely interested. I'm sorry. I'm definitely interested to know about, the Title 38 and the education requirements. I know Rule 21, has 15 hours of continuing education, 3 of those in ethical, 12 in, general credits. But what can we do as a state to align with the federal recommendations, to align ourselves to do what the majority of the population really needs, just something as a victim and survivor, and continuing to have to go through the court system. Just terminology sometimes used as a trigger. For example, starting the meeting, which I know that the intent was not negative or ill in any way, shape, or form, but it brings to light the term rocket docket was used. That was a huge trigger to me, because what that meant was that my case wasn't important. It meant that it was going to be flown through. It meant that it wasn't going to be given the time needed. if that makes sense, from a trauma-informed approach. That term we all know occurs. And it's very alarming, like, whoa, okay. So there's some things that we can do as a state to help the majority of the population who is a trauma victim of some sort.
Hey, Heather, this is Michelle Consiglio Young from the Administrative Office of the Courts. And I've obviously also talked to CLE and BJC as far regarding their conversations with you. I'm not sure that that's exactly what they told you as far as our requirements, but we do have domestic violence training requirements for the judges that we comply with through this very coalition committee. Every year, the general sessions judges, the juvenile, as well as your trial judges get that training on domestic violence. In fact, several of our judges on here, some who have left, but were on here earlier on panels for that with our judges. We report those sessions to this coalition and committee. And we go through very rigorous training with our judges. As far as the juvenile judges, basically their whole conference, all of their training is in one way or another training on trauma to children. I mean, that is what basically they focus on, and their training is on as well. It just, they have the discretion to decide what exact topics are presented to them every year based on, things that change. We've had so much ACEs training, and then it evolves and it changes. So we do change that, as every year, and they request information they want to hear. We make sure that when we see issues bubbling up in the court system, that we add those topics and trainings to their conference agendas. So we do have pretty rigorous training here. I don't think I've talked to you directly. I don't think we've connected, but I'm happy to go through that with you so that you can understand how many trainings the judges get every year. And what is in our code. So just putting that out there.
Yeah, thank you, Michelle. I would appreciate to connect because what has been relayed to our organization is that there is no required training, meaning that they can do it. And there are many judges that are passionate and many attorneys that are passionate and do that. And we're not disputing that. It's that it's not across the board, and that the CLE told us that they do not differentiate between roles. And their exact example to me was that a tax attorney and, let's say, a chancery court judge, or just anybody else in the family court system or in the domestic violence, that they could do the exact same CLE requirements under Rule 21 and be sufficient for their 15 hours annual. So what was told to us was that there is no role differentiation, nor are there any set requirements for domestic violence training, that they don't have to do it.
Well,
I would say
CLE would not keep up with that. Just so you know, like, our CLE commission doesn't track exactly what everybody does as far as if they're required to do it or not. They're tracking your hours, that you're submitting and approving, different courses that are requested to be approved to them. It's just a different role that they have. So just so you know, kind of how that's separated, within the state. As far as, training requirements that would be required for the judges to hear and comply with every year, that would be something that would be set up and administered and tracked through our office, not CLE.
Okay, I guess maybe we can connect offline because I'm not quite following you. For their ability to practice law, there is no requirement for domestic violence training.
There is not, that I'm aware of. CLE, all attorneys have to get CLE.
Mhm.
And it's like you said, they don't tell us what kinds of CLE we have to get, but obviously, like, for example, I'm an assistant DA. I'm going to want to get that I'm going to do CLEs in the criminal justice arena. And some of that will probably include trauma-informed counseling. You know, a public defender is not necessarily going to be doing trauma-informed, you know, CLEs. They're going to be more trying to get services for their clients, which be drug and alcohol and mental health issues. So it really just depends on which attorney and what they do, what they specialize in. And so the CLE Commission cannot enforce like making people get a certain kind of training. Because if I'm a defense attorney, I could be doing criminal law, I could be doing bankruptcy, I could be doing all different kinds of law that I have to get CLE in each of them. So I think the answer is the judges are doing a really good job trying to make sure that they get specialized trauma-informed training, but I don't think any other attorney, maybe outside of judges, has to get a specific kind of CLE. If anybody disagrees with me, please speak up.
Yeah, Sarah is right on that. I mean, there's not an across the board, you know, type of requirement for all attorneys. I mean, the judges, we, you know, have some requirements for the judges based on, you know, what's required here, you know, federally. But I do think, Heather, it'll be helpful for us to just talk offline, just so you can, just to know the organization, you know, of everything and how it all breaks down within how our state's set up with who tracks what and all that kind of thing.
I'd be happy to connect.
Thank you, Heather. We also had one written comment submitted before the meeting today that I think it was sent out to the council either yesterday or early this morning. And the question is, what is being done or considered as far as laws pertaining to convicted male abusers owning businesses that market to and are comprised entirely of women customers? Why is this allowed? Why shouldn't the abuser have to list or make customers aware before they purchase or spend time with the abuser for the services he offers? What is being done to protect women in these situations? Example, child molesters can't live near a school. So how is a male abuser can own and operate a business that markets and services female clients without them knowing? This was a comment submitted from the public. I don't know if anybody has a comment or response here. Kathy, is there anything you want to direct about Howden?
I'd like to say thank you for that comment. Again, you know, this body doesn't make laws. We don't take positions on the body as a whole on legislation, but we very much appreciate that comment and certainly can understand why a survivor would be concerned about going to a business where there might be a batterer who's the owner of the business. So again, we appreciate that comment.
Yes, thank you. Okay, with that, that is the conclusion of the agenda for today's meeting. I know this went a little long. Thank you everyone for your time. And the council will convene again in March. Thank you. We are adjourned.
Thanks, Courtney.